So it was bound to happen. The Watchtower organization has appealed the Norway verdict, which stripped them of their religious status, thereby losing the state funding that the Norwegian government pays to all registered and approved religions in the country. In addition, they have lost their right to appoint ministers to officiate at weddings. Let's break it down. I will pull up the card to a previous video where I discussed the verdict at the end of this video for more background to the issue. So on March the 28th, 2024, the leadership of Jehovah's Witnesses issued the following statement on their official website in response to the Oslo District Court's recent ruling in favor of Norway regarding the state's decision to deregister the local Jehovah's Witnesses community and deny them any further state funding beginning in 2021. It says, on March 4, 2024, the Oslo District Court upheld the Norwegian government's decision to revoke the legal registration of Jehovah's Witnesses in Norway. Jehovah's Witnesses in Norway will appeal the decision. The county governor of Oslo and Viken revoked our registration at the end of 2022. The Oslo District Court temporarily suspended this action on December the 30th, 2022, pending further investigation. The position of the state now remains that it will continue to deny legal recognition to Jehovah's Witnesses in the country of Norway unless we change our practices regarding the removal of unrepented wrongdoers from the congregation. The decision to deregister Jehovah's Witnesses denies us the financial aid and other benefits that the government provides to over 700 registered religious communities in the country. Additional consequences include losing the right to appoint and authorize ministers of Jehovah's Witnesses as officiants for weddings. While we await the outcome of the appeal, we will continue to pray concerning kings and all those who are in high positions, so that we may go on leading a calm and quiet life with complete godly devotion. This statement on their website is disingenuous and smacks of disinformation. In their public statement on their website, Jehovah's Witnesses failed to provide readers with the March 4th, 2024 court judgment of the Oslo District Court so that they can determine the facts for themselves. Furthermore, the leadership of Jehovah's Witnesses claim that they have been denied legal recognition to the Jehovah's Witnesses in the country of Norway unless they change their practices regarding the removal of unrepented wrongdoers from the congregation. This statement is brazenly absurd, misleading, and an attempt to spread disinformation regarding the reasons for being denied legal recognition. The court recognizes the right of Jehovah's Witnesses to determine who can be members of their religious community. However, concerns were raised that their shunning practices infringe on the rights of children and potentially limit religious freedom for departing members. Citing these concerns, the court found grounds for denying state funding and religious registration under Section 4 and Section 6 of the Religious Communities Act of 2020. It's important to note that the court decision doesn't restrict the core religious practices of Jehovah's Witnesses in Norway. They can continue their worship, expel members, and share their beliefs. But throughout their litigation battles in Norway, they have attempted to confuse and distort their religious practices. This isn't the first time concerns have been raised about Jehovah's Witnesses practices in Norway. However, the court's decision emphasizes the importance of balancing religious freedom with the rights of individuals. So let's break down the key points of the court judgment in the Oslo District Court handed down on March 4th, 2024. So this is what it states. The state at the Ministry of Children and Families says, in short, the state has asserted the decisions are valid. The crux of the matter is that a religiously motivated practice of exclusion and treatment of those who leave the religious community cannot override basic norms in society. The legal questions are whether the practice is affected by Section 6 of the Religious Communities Act and whether it is in conflict with or protected by human rights. There are two circumstances which provide independent and sufficient grounds for denying Jehovah's Witnesses grants and registration, according to Section 6 of the Religious Organization Act. Firstly, the Jehovah's Witnesses' practice of avoiding contact with former members means that the religious community prevents the right to free expression. In violation of the Religious Communities Act, Section 2, ECHR Article 9, the Constitution, Section 16, and the UN Convention on Civil and Political Rights, Article 18. Secondly, the practice also involves a violation of children's rights. Minors who have been baptized can be excluded in the same way as adults, and minors who, prior to baptism, have the status of unbaptized preachers can be excluded from social interaction if the minor commits acts which in the religious community are considered a serious sin. In the preparatory work for the Religious Community Act, the legislature has expressly mentioned negative social control aimed at children and psychological violence towards children as conditions to be covered by the Religious Communities Act, Section 6. That such conditions constitute a violation of children's rights is also supported by the Convention on the Rights of the Child, Article 19, which gives children the right to freedom from all forms of violence. In the Children's Committee's general comment on the provision, isolation is mentioned as an example of psychological violence. Whether or not Jehovah's Witnesses are registered under the Religious Communities Act has no bearing on the religious community's status as a legal person and independent legal entity, or whether Jehovah's Witnesses are to be considered a religious community. It is clear that Jehovah's Witnesses are still a religious community, according to the definition in Section 2 of the Religious Communities Act, and are thus covered by both Chapter 1 and Chapter 4 of the Act. In other words, there has been no separation of the religious community as such. The effect of being refused registration under the Religious Communities Act is only that Jehovah's Witnesses cannot apply for grants from year to year, and that Jehovah's Witnesses cannot be granted the right to marry. The decisions do not conflict with the ECHR or corresponding constitutional provisions. Article 9 of the ECHR does not, in principle, impose a positive duty on the state to provide religious or religious communities with state subsidies or the right to marry. If the decisions are nevertheless considered to involve an intervention in the freedom of religion, it must be seen that it has occurred in an area which initially enjoys limited protection under the Convention. In any case, the intervention is permitted according to Article 9, second paragraph of the ECHR. The decisions are based on the Religious Communities Act and pursue a legitimate purpose in the form of the protection of public order and the rights and freedoms of others. They also fulfill the requirement of being necessary in a democratic society by building on a reasonable balancing of the various interests that apply in the matter. The decisions are not a breach of the state's duty to act neutrally and impartially in the face of different religions and views of life. The state has neither taken a position on the internal organization of Jehovah's Witnesses, made a statement about what constitutes right teaching from a religious perspective, nor taken sides with possible different directions within Jehovah's Witnesses. The state's duty to act neutrally does not mean that the state is never allowed to react to practices under the auspices of a religious community. The decisions also do not imply any violation of freedom of association, ECHR Article 11 and the Constitution, Section 101. Jehovah's Witnesses are still an independent legal entity with the freedom to govern themselves even if the religious community is not registered. It is not obvious that there is any intervention. In any case, the state believes that the intervention is prescribed by law, justified by a legitimate purpose and necessary in a democratic society, and that the intervention therefore does not constitute an infringement. The decisions also do not involve discrimination, contrary to Article 14 of the ECHR in conjunction with Article 9 and or 11. It follows from the ECTHR practice that states have the right to establish arrangements where religious communities can apply for a specific status that grants specific privileges. In order for such an arrangement not to violate ECHR Article 14, it also follows from the ECTHR's practice that the state must ensure that all religious communities are given a reasonable opportunity to apply for the status and ensure that the criteria are applied in a non-discriminatory manner. In the state's view, these conditions are met. The criteria in the Religious Communities Act are objectively designed and plans are made for equal treatment of religious communities in comparable situations. Any community that commits, incites, or supports conditions as mentioned in the Religious Communities Act, Section 6, first paragraph, will be able to be refused state subsidies. These societies can also be deprived of a previously granted registration or be refused a new registration according to Section 4, third paragraph of the Religious Communities Act. The decisions are in any case factual and proportionate. So those are the key points in the judgment. In a nutshell, what the Norwegian government is saying to the Jehovah's Witnesses is, here are the rules and regulations that all religions in the country have to abide by to be eligible for registration and state funding. You, Jehovah's Witnesses, are responsible for the violations in the assessment of whether grants and registration should be refused according to the Religious Communities Act.